with Judge Stoller, and thank you very much for coming.
Hi. So I know there's a lot of things that a lot of people have questions about, and I think a good place to start with that is to talk a little bit about some personnel additions that we made in the court. And I say that in parallel to a lot of the questions that people have, because that has an effect on it. Most importantly, we recently hired an attorney named Peter Kempner. Some of you may know him. He was in the legal aid and services world. The court system, like many other people and entities, has a lawyer. The court system's lawyer is the Office of General Counsel, and the Office of General Counsel hired Mr. Kempner to be an attorney who specializes on housing issues. As you can imagine, most of his focus is New York City, but not all of it. He deals with housing issues upstate as well. But he has started working on a lot of projects that have a big effect on a lot of things that a lot of folks here are concerned about. We also recently hired, after too long a time for not having this person, a guardian ad litem coordinator, a GAL coordinator. That's Jacqueline Burns. I think that GALs have come up earlier today, as I understand, and just to give a little background for why having a GAL coordinator was something that really was needed. During the pandemic, a number of GALs that we had quit basically, and the ones that were left really got very stressed out because we were relying on them very heavily to point a number of cases to each one. And one of our best guardians of litem, Stuart Adler, very tragically died earlier this year. And obviously, it's a tragedy for him and his family, and I of course wish him well, but it also was difficult for guardians of litem because he put in such a wonderful amount of service. So the good news about having a guardian ad litem coordinator, that was happening at the same time that the supervision program is moving internally within the Office of Court Administration to be under the Office of Civil Court. So we got set up to have a big training, and we have now more of a machinery in place to recruit new guardians ad litem. For the other issues that a lot of folks are concerned about, I've been working on them, but fortunately since about a year, I've had, as I mentioned, Peter Kempner working on them. I want to talk about access to counsel and attorneys for tenants. I saw Masha Gindler here, who's the chair of the Office of Civil Justice. The court system has been talking very frequently with Ms. Gindler about problem solving, some of the gaps in justice that there are right now. I think it was, I don't know, it was 2 weeks ago actually, I testified before the city council. We were having a hearing, and even Ms. Lori was there too, that I think was very successful in underscoring to the council the need for more funding for this program, because right now I think it's not enough to provide attorneys for all eligible tenants. I think the good news is I know that both legal aid and Disney recently had fairly substantial hiring classes. They know the numbers better than I do, but I spoke with them, and it was really heartening to see so many attorneys out there. So my hope is that with the new hiring that we've got, maybe we're over the hump that we've had to deal with in the past, and trying to deal with the problem of recruiting and retaining attorneys. And if the new administration comes in and they have a big commitment to access to justice for tenants, I think I'm optimistic about what it is going forward. With regard to attorneys for tenants right now, an issue that has come up that I've been asked to speak about is the intake in Bronx and Queens counties, particularly those counties now have virtual intake. Virtual intake has a couple of advantages that we wish to preserve. One of them is the fact that a lot of folks who show up for intake are, they're working they're often at full jobs. They perhaps have child care responsibilities, or they may be elderly or disabled. So trying to maximize the number of times when they can appear virtually instead of having to come to court is something that is very helpful in that scenario. Also, for those counties, particularly in the Bronx, we have a facility that is not adequate to our uses, so that means we have very long lines coming in, and the more that you can reduce the number of people waiting in line to come in, the better. So there are benefits to virtual intake that we wish to provide. However, we are aware that many advocates and attorneys and Office of Civil Justice have brought to our attention that there are issues with the virtual intake, particularly in Queens things that have been brought to our attention. Where basically it's been hard for OCJ and for the attorneys to reach the clients who are coming in. And we've looked at the numbers on this, and I do think that there are improvements. So I've been talking to the supervising judge in Queens and to the administrative judge, Judge Ali, who is technically my boss. He's the administrative judge of the civil court, which is the court over which the housing board is a part of. So we have heard those criticisms, and we're trying to figure out different things to do, like have the clerks engage in extra information gathering so that they can let OCJ and the providers know if someone needs an interpreter. They're also talking about trying to get some space for Office of Civil Justice to have someone situated so that when the tenants come in to answer the payment proceeding, they can get the information so they get a jump start on that, to get judges to be able to refer cases to OCJ directly in case the tenant hasn't gotten that as of yet. And to also try to get more information about when a call from OCJ or legal services provider can be expected, because a lot of times in this day and age, I don't know about you, but if I get a phone call from a number and I don't recognize them, pick it up. And I think that's been a frustration with a lot of OCJ and the legal service providers have experienced, that they call up tenants and no one picks up, and then the voicemail that doesn't get responded to. So if we can get like a window period for them to call, those are the measures that we're looking at to try to address those problems. Another thing that Peter Kepner has spearheaded that I'm excited about is we're going to start a special card for veterans. There's a lot of benefits that veterans are entitled to that relate directly to housing boards. Veterans, for example, are entitled to the type of assistance they'll pay arrears that you see with other types of folks, like one-shot deals and so forth. And there are certain laws that apply to veterans as well. So to kind of focus our attention to these benefits that veterans are entitled to, we do want to start a special veterans calendar. There's probably not enough cases to take up an entire calendar or an entire part, but to devote that attention to it and set it aside and perhaps have a liaison. The city government has a special, I forget what it's called, but it's an office that provides a liaison to the Veterans Administration to have them interface with the court directly. We have liaisons now with APS and so forth. That's a thing that we're looking to do, and I think we're going to pilot that program in Brooklyn. So right now what we've started a field in our data gathering, which is in the UCMS system, the Universal Case Management System, where we got a field to ask people at the answering stage or in the first day on an holdover if they're a veteran, not create that field, get a sense of the data, what the need is, and then we'll move on to the next phase. Another thing that I'm interested in looking at, and this has come about because of the issues that we've talked about with access to justice, and I'm interested to hear what this community and anyone else thinks about it, is right now, the way that down payments work, as you all know, is the tenant answers, and then there's a court date about some interval of time after that. And that's not the way that it works for rollovers, and that's not the way it works for the rest of New York State. I'm kind of curious to know what it would be like if we were to change that, because the reason why that is because there's a local rule, and the local rule is set by the administrative board, which is staffed by people appointed by the chief judge of New York State. And so I think it would be a good idea to contemplate maybe revisiting that issue and seeing if it would be better to have a non-payment petition being served that just has a court date like the holdover petition does. And the big benefit I see for that is rather than put people in a situation where they have to come to the courthouse multiple times, like I have to come to the courthouse to answer, and then have to come back sometime later from the court date, and then we refer it to, okay, that's support. So this is what I think before we go and do this, we have to make a presentation to the administrative board, and that would require gathering some information. So I'm gathering some data about this right now. And like I said, Peter Kepner is working on that. So with those personnel changes that we've had, with the projects that we're looking at, about access, and let me just get back to access to justice for a moment. Besides the issues of intake that I talked about, the court system has also been having a number of talks with OCJ about besides the specific issues that I've talked about as a general matter, trying to expand access to counsel as much as possible. One of the things that came out of past talks like that is the administrative part in Brooklyn. I'll be very blunt and honest that I think that it's been disappointing the way that project has ended up working out. And I think we want to think about alternatives to try and narrow the gap between the number of tenants who are eligible for help and need the help and the capacities of legal service providers. So whatever that can be done from HRA's point to perhaps boot out as many cases as possible can certainly be helpful to that. And OC has been sharing our data with HRA to that extent to give the HRA, and it's public information, we've given them kind of a more direct line so they can know if someone who's coming, if there's someone who is a client of theirs who's getting help through agencies. And so trying to figure out how to leverage that to and do work like that. Besides that, the other personnel issue at the court that's been very good news. I've done a very big hire recently in court attorneys. We've had a very big challenge, just like legal services providers, both finding court attorneys and retaining them. We've tried something a little different this year, which is hiring court attorneys straight out of law school. So obviously we need a lot more training than the way we've done before, when we've done lateral hires. So we did have a big training for that, and we had longer CLEs, but having more court attorneys, it really is a great assistance to the court in trying to give every case that it attention it deserves. Because the more court attorneys that you have, the more just like when you get up to 2 court attorneys per resolution part has been our goal, then I think that it really gives the court the resources it needs so that all the issues that really need and deserve a fair hearing for them to come out. So that's, I apologize, my time here is a little bit somewhat limited. I have maybe another 15 minutes or so, and that's kind of the basics in terms of our updates with personnel and how we've been addressing some issues that we've been dealing with. Ms. Laurie, I don't know if there are other questions that folks have.
And everybody, this QR code on the table for questions like we did this morning, and they'll come here for the judge. Okay. So if you have questions, you scan on the table.
Or I think also, if someone wants to read the hand. Okay, I see a hand over here.
Hi, 3 thoughts. One, would you consider giving support staff ID for nonprofit law firms so they don't have to get online with everyone else?
Kind of like a secure pass.
Yeah.
When you say support staff, and support staff, I think might be
paralegals, independent organizers who are also going to be in on the case, being supportive to the attorney, having to wait online with everyone else, which is contributing to a delay. And having a special pass, whatever you might call it, would help process that. Secondly,
I apologize for getting on my phone. I'm getting on my phone because I don't have a pen and paper. That's how I'm writing it down.
Okay. And then you mentioned something about virtual intake. Do you have a sense of when it might come to Brooklyn? This year, next year?
Brooklyn, right, the intake in Brooklyn is a special case right now because it is, we have the administrative part, which like I said, to be very honest, I've been a little disappointed in the way that that's worked out. So we definitely want to do something in Brooklyn. And that's sort of tied up with talks that we've had with HRA. So, and I suspect when the new administration comes in, there might be a different direction about how that's going to go. So I think before there's going to be changes to intake, we'll probably see what happens with that and with the other issues that I was talking about in terms of trying to reach out to tenants as far upstream in the process as possible so that maybe we can resolve whatever, like, let's say a rent arrears issue before the case comes to court or early enough in the process that it doesn't even turn into active litigation. So like I said, I think there are benefits to virtual intake. I think there are problems with it as an observer. And hopefully we'll try to learn from the problems we've observed in the Bronx and Queens and apply them going forward. So I don't know what time frame for you at the moment in terms of that, but that is, the issue in terms of that. I see a question came in. With plans for staffing to hire more interpreters, especially more Spanish in the Bronx. So to explain about interpreters, I hate to keep going back to the pandemic, but that's the root of the issue. During the pandemic, we lost maybe like 20 or 30% of our staff interpreters. I mean, they quit. They're okay, but they quit. And in order to become an interpreter, you have to take a test, and the test is not given virtually. So we couldn't have a test for a couple of years during the pandemic. So at the time we were getting the test again, we were already really deep in a hole because a lot of interpreters had left. So we've been digging out of that hole with interpreters since then. And it's, it's a real crisis. This is not an issue only with our court. This is an issue that is a court-wide issue in terms of family court, Supreme Court, criminal court, other courts like that. So one of the ways that the court administration has been trying to deal with that is to try to change the test, because I think that there were problems where I think there were interpreter candidates who took the test and they failed even though they're like fluent in the language, and I think there were concerns that the test might be outdated. So interpreter staffing is a big challenge. It's not just our court, it's all courts, but it's a genuine issue. And we have to deal with it. There's another question here for virtual court appearances. Does the court provide litigants with any line of queue numbers so they know how much longer they may have to wait before seeing a judge? We usually don't see a judge on virtual intake. Oh, you mean for any virtual court appearances? So for virtual court appearances, that's really difficult. I can tell you that I do think that virtual court appearances, they can be very good for many reasons. Like I said, a lot of folks who have a hard time coming to court because of work obligations and child care obligations, and being able to appear in court virtually is a good thing. But from where a judge sits, especially for a resolution part, I can tell you that sitting in a resolution part with a calendar, 40, 50, 60 cases, whatever it is kind of like being a catcher and there's 4 pitchers throwing baseballs at you. And when you have a virtual part on top of that, it's like there's 10 pitchers throwing baseballs at you, because you have to deal with, I have someone's handing me an workshop calls, and now I have an interpreter and I do that case. Now we have the 2 sides I need in this one coming up. When you add to that someone who comes up before you, there's a virtual appearance, it's very difficult to keep that all in line. Especially because the way that the funnel in which cases come up to a judge is there's a court officer and the clerk and the court attorney. But with a virtual appearance, that sort of bypasses all of that, and they just parachute in front of the judge, and then the judge has to sort of reconcile that with whoever else is in the room. So it's very difficult to give someone like a queue number that says, this is when you're going to be seen by the court, and have that actually happen. It's logistically difficult. I know that they are working on a new platform to replace Teams, which is good, because I will say this in public, I hate Microsoft Teams. I think it's a bad platform. So they're working on a new platform that is specific to New York State courts. It's just a proprietary court application. And they say that some of the problems I'm talking about in terms of not knowing when someone is appearing virtually and getting them lined up with people that are in person in your courtroom, it's supposed to take care of that issue. So hopefully, if we get this new platform going that replaces Teams, and that can maybe address the issue that you raised. See here, there's a question. Can there be a better? Sorry, this isn't coming through. Can there be a better system for checking in and contacting opposing counsel rather than walking around trying to find each other? I'm sure, as you know, most business model, most management firms is a volume practice. That can work to a tenant's advantage, but the downside of that is that I think for tenants with counsel, that works to tenants' advantage, because that means that the tenant's counsel can do things like draft the STIP in advance or do other things to try to get a little bit of advantage for your client, while the landlord's attorney is doing more cases than they really have the capacity to handle. The downside of that is that they check in and disappear. I mean, what we tell judges to do, and what I think a lot of judges do when they set up the court rules, is to say if you check in and then disappear, if you don't come back before it pertains to discretion, to dispose of the case in any way that the court sees fit. How it goes after that is, it's hard to systematize and it's hard to make a one-size-fits-all rule. And the reason for that is, and I think an important distinction between judges and legislatures is a legislature makes a rule that applies to everybody, but a judge has a specific case with specific facts that sometimes a one-size-fits-all rule doesn't really make sense to apply to. So to have a general rule that says that all attorneys must do this or this consequence will follow won't account for a specific situation where maybe it doesn't make sense to apply that rule. So instead, the general rule that we tend to have, which is if an attorney's not back by a certain time, then there'll be some kind of consequence. You balance that against also the fact that sometimes the other side's lawyers appear late, sometimes pro se parties appear late. There are default times, but we don't really want to default cases because we'd rather deal with cases under merits and not create another order to show cause. So we often ask people to either not default or ask attorneys to vacate defaults when attorneys or litigants show up late. So there's a lot that goes into this that's difficult to make a one-size-fits-all rule for or one system for. But the current core rules that we have are about as best as I can offer right now. If someone wants to make a suggestion, I'll hear it. The next question I see: what can the court do to change the climate of how some tenants are treated by landlords or landlords' attorneys who are bullying or hostile, putting pressure on tenants to settle in unfavorable ways? So no one has to speak to anyone in the hallways, and there are announcements that are made to try and stop that and say, if you want, you don't have to speak to a landlord's attorney. In the hallway, you can only speak in the presence of a court attorney or a judge, if that's the way you prefer to do it. I think that, there's obviously been a long legacy in housing court of what they call the hallway discussions and so forth. And if we are as fully staffed court attorneys as we're finally getting up to the point now, where we have 2 court attorneys per resolution part, that's becoming a lot more feasible to do it that way instead of do it the way that it used to happen in the past. Now, obviously, you can be fully staffed court attorneys and still can be the case that an attorney and a pro se tenant could be having a conversation in the hallway. Of course, the problem with the hallway is it's difficult for the court to police that because we don't see what's going on, we don't see it's there. So, as much vigilance as possible is something that has to come up, and anyone who witnesses something that's inappropriate should be letting court personnel know, and attorneys should be called out for inappropriate behavior that they engage in. The court has various tools at its disposal. One thing that comes up is that it's both a matter of ethics rules that say that you have to treat an adversary with courtesy, and rules that the deputy chief administrative judge for justice initiatives has set forth about racist, sexist, homophobic, transphobic, whatever conduct that's unacceptable for attorneys to engage in, that judges have really been trained on this, and if something comes up, it's something that really should be brought to a judge's attention. And if a judge doesn't deal with the situation appropriately, you should be reaching out to the supervising judge or to me, because everyone has the right to advisory courthouse, and no one should have to be dealing with inappropriate behavior. So whatever you see in that, and one other thing I'll add is RPAPL 746 provides that judges are supposed to be allocating stipulations to pro se tenants to make sure that the thing the question's asking about, which is an inappropriate, like bullying the tenant to sign a stipulation, doesn't happen. And New York City Civil Court Act 110 was amended to say that the way that a judge complies with RPAPL 746 is a part of the judge's reappointment process. So if you believe that a judge is not appropriately allocating stipulations to make sure that if there's been some kind of bullying or something like that, if you think that that's not done, certainly again, reach out to the supervising judge. Every allocution that a judge does is digitally recorded, and we can all listen to it. We all have that capacity. So if the judge is not appropriately allocating and making sure that the tenant hasn't been spoken to outside in some way that's an appropriate allocation, we can hear that and then try to problem solve. And if that doesn't work, then like I say, it is an issue in reappointment. So there's a number of things that can be done to address that. Next question, how is it safe for a non-citizen to attend court in person, considering what's happening with mass deportation initiatives? This, I agree, is a really big problem. The court system has promulgated a policy about how to deal with federal, and I guess it's called licensed CPB, because some of the things that we've seen in videos or something with people acting in ways that none of us want to see happen. It's not just ICE, but it's also CPB. So there's a policy that has been promulgated by the court that speaks to the necessity for a judicial warrant before they can engage in enforcement activity in the courthouse. A judicial warrant is distinct from the kind of warrant that they have from the immigration court. That being said, I mean, it's not just people, I think people regardless of their immigration status have been harassed, have been arrested and disappeared, and this is a very big problem for everyone. I spoke before about how there's some benefits to virtual appearances. This might be one instance where a virtual appearance can be a safer thing to do. So to the extent that that's something that can occur, I would encourage whatever. I realize I'm here with tenant organizers and people engaged in advocacy. So to the extent that you want to let people know about the availability of that, certainly request that. That's one thing that can be done. So I keep having to click on these because the field doesn't have to be question. For Brooklyn intake, can you briefly describe when you would try to reach people to work out payments? So for example, so they may even avoid court. So the question is, like, how far upstream can we get in terms of trying to resolve a non-payment case before it really comes down to litigation? This plan or program is not something that's fully onboarded yet. So the more that we're able to flesh this out and get this out, we'll try to disseminate information as best we can. Right now, the way it works is on the day that the petition is returnable, the tenants are, or it's not just tenants, it's also non-tenant occupants. They're referred to the OCJ and HRA, and the case gets adjourned for 45 days. What we've observed is that HRA has not been moving cases out by paying the arrears. So, and that's been going since February 2023, so that's kind of a long time now. So that's the way it's going now. It hasn't really worked out that way. We're going to try something different, but we don't have that yet. Next question, are there plans to add additional HP parts or to otherwise address backlogs getting decisions in order? So the number of HP parts, I just want to stress this from the outset, that doesn't affect the first day that the HP case is on. The reason why HP cases are returnable the days they are now is because of HPD. When the HP cases started, we order the HPD to inspect and go and then deliver the results of the inspection to the courthouse. For HPD to inspect based on their staffing, based on what they've got, their resources, it takes them about 2 weeks to get someone out there. After that, it takes them another couple of weeks for them to get the inspection report drafted up and written to the court. So no matter how many HP parts we have, the first time a case is on, that timetable is going to be pretty much the same. That's kind of the timetable for when HPs are returnable now. When an HP is returnable, I have given trainings on HPs to judges. We have scheduled trainings under HPs for judges. I have told judges it should be the rare case in an HP case where you do not give an order to correct the first day. HP cases have very few defenses to them. Service is, the legislature has made service as they facilitate it as much as possible. It should never be an issue. Basically, the only, I think, legitimate defenses to an order to correct are, I'm not the landlord, this is not a lawful occupant, they never actually mailed the papers, which almost always happens. And, economic infeasibility, which is a very rare kind of defense in very rare kinds of cases. Because of that, and because of multiple dwelling law 323 that says that the HPD inspection report is a prima facie proof of the conditions, there should be orders to correct the first day. The real issue comes, I think, in terms of decisions and orders if you're talking about after that, would come the litigation after that when the landlords don't do what they're supposed to do, and that's when you have motions for like civil penalties or contempt or something like that. In terms of those issues, what I can say is that housing court judges have more motions and decisions that we have to write than we've ever had before, even as the number of cases has gone down. And when I say the number of cases gone down, I'm talking about the pandemic was sort of an anomaly. If you look at from like, let's say the 90s up until 2019 pre-pandemic, it was going down a lot. Then during the pandemic, there was a lot of restrictions on eviction, so it crashed. It went back up once those restrictions were lifted, and now they've started going down again. Filings this year, they've never gone back up to 2019 levels. They went back up after 2022, and then they kind of flatlined around 23, 24. This year, they're less. They've gone down some more, but even as they've gone down, because of a very good thing, which is more tenants having lawyers, there's a lot more motions, a lot more decisions that judges have to write. So we're still staffing cases as if we don't have to write decisions, but now we have a lot more decisions to write. That's affected the HB Part 2, and so it does take a longer to get decisions out. The number of HB parts that we have depends on the number of total cases we have. So for example, during the pandemic, when we had more HP cases, we did increase the number of HP parts. And when I was at an HP part in Manhattan in 2019, we didn't have enough HP cases to justify having a full part for it. So 2 days a week, I was doing trials. So the way that we staff judges and HP parts depends on the number of cases. If you look at it right now, the number of judges staffed per HP part is roughly proportional to the number of HP cases we have. That's in Brooklyn now, we have more than one court part doing HP cases. In the other counties, it does tend to be more proportional. The next question is Brooklyn Housing Court moving. So, if there's one thing I think tenants, landlords, the court, we can all agree on, 141 Livingston Street is an unacceptable facility. That's a common enemy, we don't admit against that. Brooklyn Housing Court was supposed to move to Charlemagne Street several years ago, and then there was asbestos that was found, and then they had to bid it out, and that process ended up pushing everything back several years. And the last date I heard was 2027. I feel like it's an ever-receding horizon. It's deeply frustrating because it's a terrible facility for tenants. It's terrible for attorneys. It's terrible for landlords, judges. It's terrible for everybody. It's just an awful facility, and I wish it would move as soon as possible. But 2027 was the last date that I heard. As an advocate, how do we get the judge's attention and permission if we have facts relevant to the case? And to answer questions about applications, etc. Sometimes when clients panic and forget. If you're not an attorney, you cannot speak on behalf of someone else. There are occasions when there is someone who's working with a litigant who can, as a friend of the court, speak to a judge. That's the way that I would frame it, and I would say frame it first with the court attorney. Make clear that you wish to address the court not speaking for a litigant, because you can't do that if you're not an attorney, not in place of a litigant, but to do it as a friend of the court, as to try to offer some assistance and help. That's the way you frame it. If you frame that to the court attorney, say, I have information, again, I have information that can be helpful to the judge. That is the way to get the attention of the court, because I think that we occasionally see people who want to practice law without a license, which is, they don't want to do that. But what they want to do is amounting to practicing law without a license. And that's a problem, that's a crime, that's something judges don't want to see. So I would say, frame it in that way as being as of assistance to the court, as of assistance giving information to the court, and have that conversation first with the court attorney. That would be the best way that I would say. Where can we go if a court attorney is often disrespectful to various legal services organizations? Reached out to the supervising judge multiple times. Okay, the supervising judge has not given you relief, I guess. The next route to go to would be me, because I'm the supervising judges, so reach out to me. My address is 111 Center Street, New York, New York. You can write me, it's 10013. Let me know the name of the court attorney, and if you reach out to the supervising judge, then you would have to investigate and see if there's some corrective action that can be taken. It's about 154, so my time's running a little short, but I'm trying to get to the questions here. Are non-attorney advocates allowed to help pro se tenants create lists of accounts and upload affidavits evidence? I don't see why not. I don't actually know the answer to the question for sure, but I don't see why not. If there's someone who knows that information, they should be able to, but if you want a more definitive answer on that, I would probably have to consult someone and get back to you. Can I reach out to you with
Yeah.
that answer? Again, sorry about the phone, I'm taking notes. I'll just write it down, attorney myself. Are there issues found in group HP actions, tenants filing without attorney? The issue with filing a group case is that you want to make, it's difficult to speak on another litigant's behalf if you are not an attorney. So that raises an issue because you always want to make sure that every single litigant in a group case is actually on board with it, and you're, you don't want to see a situation where someone says, why is someone drafting me into being a petitioner in this case? That's not necessarily what I wanted. So that is an issue, an issue with that I know of. Offhand, if there's something more specific than that, I would say reach out to a supervising judge or it's why isn't a collapse ceiling considered an emergency HP? I mean, I don't make a distinction necessarily between an emergency HP and an HP action. An HP action is an HP action if there's a C violation. And like I say, on the first return date, the court should be entering into in order to correct the C violation within 24 hours or the first access date as required by the administrative code. And if there is a collapsed ceiling, the problem is that if you don't have an HPD inspection that finds that, then you would actually have to prove that. And you'd have to prove that at some type of a fact-finding hearing, which is probably going to take more time to schedule than it would if HPD just found a violation and let the court know about that. Then it's prima facie proof. You don't need a trial for that. Without that HPD violation, then you're in a situation where you have to prove it at some type of fact hearing, and that ends up consuming probably more time than if you went through the course of having HPD place it as a violation. Has the court contemplated a referral system between HP parts and legal services providers when an individual person litigant files an HPD violations or conditions that are obviously serious and might be broken by effective intents or occupants? HPD is automatically a party to HPD cases, and my experience with the HPD attorneys is that they are very zealous advocates for the enforcement of the housing maintenance code. And I because of that, and because the legal services providers do have diminished capacities to represent all the tenants that they are obligated to represent, the court generally has not referred HP litigants to legal service providers. But I will say, if the legal services providers do want referrals and communicate that to us, I will be more than happy to refer litigants to legal services providers, because I think it's always preferable to have someone appear by counsel rather than by pro se. In an imperfect world, there's a lack of capacity to represent everybody, probably in a triage scenario. We want those resources going toward representing eviction cases instead of HP cases. But if legal services providers communicate something different to us, I'll be happy to instruct the HP judges to refer cases to legal services providers. So it's about 2 o'clock. I feel like I just talked for a long time. I apologize for that. I don't have the best voice in the world, but thank you all very much.
No problem. I'm a little bit past my time, so I got.
Yeah.
So
Great.
thank you all.
Okay.